These are some frequently asked questions regarding amending or revising the California Constitution. So, what is required for an amendment to the state constitution? It requires passage of a state ballot measure approved by a majority vote of the state's electorate. Who can propose amendments to the state constitution? They can be proposed by legislators or by the voters. Section 3 of Article 18 of our state constitution provides that electors may amend the constitution by initiative. What can the legislature do? The Constitution says it can be amended or revised by the state legislature, of course, followed by a vote of the electorate on that particular ballot measure. And this process is also allowed pursuant to Article 18. And Article 18 includes some specific rules for amending or revising the state constitution. Does the governor play a formal role in legislative action on a constitutional amendment? No, the governor does not act upon a proposed constitutional amendment. Can the legislature call a constitutional convention? Yes. The legislature may submit at a general election the question whether to call a convention to revise the state constitution. What is required of the voters with a constitutional convention? If a majority of the electorate votes yes on the measure placed before them by the legislature, then within 6 months, the legislature is required to provide for that convention. And delegates to a constitutional convention are voters that are elected from districts as nearly equal in population as may be practicable. And finally, what happens with the legislatively proposed measure? In Section 4 of Article 18 of the state constitution, it provides that a proposed amendment or revision to the Constitution must be submitted to the electors, i.e., the voters of the state, and if approved by a majority of them, then the measure takes effect the day after the election, unless the measure provides for a different effective date.